guests and all the audience who are here. At the outset, you have had a good introduction by Dr. Pandey, which is an overarching perspective from his experience as well as his insights as a great scholar, who is specialized in criminal law, whereas I should plead guilty to the fact that I'm specialized as a teacher, and particularly in international law. But then engagement with international law will not make you alien to the idea of human rights, which percolates across all disciplines. So that is the courage with which I have come before you to take up this idea of teaching criminal law, aside from vetting the criminal law curriculum as the dean, and also taking the entire pedagogy and curriculum to the newer heights. In this law school, which has come among the top 3 in the country now and among the top 10 in the national institutional ranking framework of Government of India. So although it is a constituent college, we could make it to rub shoulders with the top law universities because of this kind of innovation that we have had, where Dr. Pandey has played a very, very key role, not only as the advisor to the curriculum and research curriculum, but also as the distinguished faculty on visit. So with that background, let me first take you through. Some of the students should excuse me. I suggest most of the faculty would find it very relevant. Wherever it may not be directly relevant to the students, I would request the students to take only what is pertinent to their future calling, maybe as teachers or as researchers. Because once you get into a professional science like law, whatever is the kind of career line that you're pursuing, research is an inevitable companion. Unless you research, you don't thrive, you won't do well. Therefore, I pass that message to you. Now, first of all, I would like to give this introductory slide. How many are students here? And students of CMR? All of you. Okay, good. That's nice. Now, first point I would like to say is about this whole idea of learning outcome. Learning outcome as an idea has been there as a mandatory part of drawing up the curriculum in Western countries for a very long time. Because learning for the sake of learning, although autonomy of the faculty in the classroom and in modifying the curriculum is there even in the UGC's model curriculum concept and Bar Council's nomenclature of the courses concept, the idea of looking at learning as something from which outcome has to be there has been coming in India very lately. If you look at engineering discipline, it has always been there, especially with the National Accreditation Board requirements, NBA requirements, National Board of Accreditation. With the leading institutions, it has been there in terms of NAC accreditation, vaguely, in terms of NAC hitherto will not ask directly for a learning outcome or a template where you would project your teaching curricula or your pedagogy or the outcome in certain streamlined ways. I'll just talk to you about that. But in the law field, learning outcome concept is new, and in Indian universities through the UGC's nurturing, it is new. The current NAC has introduced this course outcome and program outcome concept, CO and PO concept. I do not know if you have been enlightened on NAC, the teachers here. The entire formula is going to change. The format is going to change. It's going to be entirely online. You have to feed the data online, and there's a kind of format that they have given. So for that, the orientation to learning outcome is primary. It is the primary building block. So in every course, you have to identify the outcome. And according to that outcome, you will tailor-make your imparting of the course content. And when you impart the course content, you will have to assess the student in terms of whether the student has received that kind of content in the way you intended. So your pedagogy or your teaching style or so-called delivery method is also going to play an important role. Now, delivery method is again dependent on what we consider as taxonomy of learning. So first we look at the word learning, secondly we look at the word outcome, and what are the possibilities. You know, we have specialized training. I usually do that with my faculty from time to time, which lasts for a day, where we go through threadbare concept of possibilities. We give models from comparative jurisdictions from abroad, leading universities like Harvard or Oxford or Cambridge, and then we try to enlighten them. None of them is perfect on their own. as we human beings are. So you cull out the best and you tailor make it or customize it to your reality. That's how we do. Now, in legal education, we prepare our graduates for what? We prepare our graduates for versatile legal careers. I sometimes go and address community on this in terms of future parents and current parents. What are the kinds of careers that you can expect at the end of the law degree? There was a time when 40% students with 40% score used to come to law school. The reason is that they wouldn't find their admission to master's program, or they want to continue as students in the law school because they want to play a part in the university politics, or some of us who wanted to continue our debating career, so we continued in law because it would give 3 years compared to 2 years. I'm just giving that as a humorous example, but my entry into law was for a different reason. We had a lot of property issues in the family, so somebody had to take over the burden. But generally, I was dissuaded by my principal, go back, you have such high percentage in science, you could join, and English literature as well, so much so it was equally good kind of percentage, so much so the name that principal had known in a small city like Bengaluru at that time. So twice he said, go back, I will not admit you. This is meant for 40 to 50% kind of students. Having an 80, 85%, 98% in botany was a kind of mark sheet that was not allowed at that time. Finally, I had to say that I want to be in law. So maybe he was testing also. He was very happy, but the kind of trend in law education was like that. But after the emergence of the national law schools and after the great examples coming up in India in terms of its own brand of judiciary, its own brand of practice and scholarship, slowly India is was opening up into excellence, and thanks to the lead taken by senior professors like Dr. Menon, Dr. Pandey, Dr. Bakshi, we have excellence redefined in legal education at par with the medical education. How many of you have read the Carnegie report? One person there? Anybody? There's a book called Educating Lawyers. This is the outcome of Carnegie report, which is edited by Sullivan and others. Now this book, I've got a copy. It's available online. Now this is the book which laments that the kind of ethical commitment which the medical students have, where there is mandatory internship or so-called, the housemanship, which we do not have in law. The comparison is drawn in a very drastic fashion in terms of ethical orientation, in terms of subject understanding, in terms of clinical orientation, the most important one. So Carnegie report clearly says that the focus of the legal education should be a good mix of knowledge, skills, and values. Now, if we take a step back from Carnegie report and also look at the history of Carnegie report, like we had the McBride Commission, looking at the McBride Commission, Indian Law Commission reports also have focused on the quality of legal education. We have had the first generation law reforms dimension from the Bangalore Declaration. All the law teachers should have known this from their LLM classes, or at least in their orientation. And then after the Bangalore Declaration, we had the second generation law reform. First Bangalore Declaration slowly resulted in the emergence of the national law schools and other developments, which Dr. Menon seems to have taken up as the mission of his life, like Adi Shankara. But after that, we had second generation law reforms under the leadership of Dr. Moily as the law minister in 2010, where a lot of scholars came and shared their experience. It was a very good mix of judges, lawyers, experts from international arena, and senior teachers, etc., and law school leaders. Now, second generation law reform very clearly spoke about the need for following the Carnegie report. But I was critical of that, because Carnegie report was preparing lawyers for the courts, and Carnegie report was preparing lawyers for a particular type of substituting and strengthening the court. When National Law School was created also, we spoke about the dwindling quality of judges, because there was dwindling quality of lawyers, and in turn dwindling quality of students and legal education. So all the time we have been talking in terms of judicial system alone. If you look at the society and society's health, what ends up in judiciary is only 10% of the reality. What happens to the 90%? Are we preparing our law students to face those realities where there is a need for certain skill sets in order to tackle the threat to justice and in order to protect rule of law, as Sir was emphasizing, in order to have a society which is constitutionally governed, a society which has a very high sense of justice. Justice and rule of law go hand in hand and as complementary concepts or embedded concepts. So if you look at that in the Indian context, given the kind of big gaps between the rich and the poor, and given the kind of what we call as inequalities, which are very blatant, hitting you on the face, is the role of the legal education just limited by the standards given by Carnegie report? Could that be only the tall order, or do we have to indigenously discover our own dimensions of how to make legal education relevant and how to make the law graduate relevant? My law graduate will not be only satisfied with the theoretical knowledge or being prepared only for the courts. Although my law graduate has to be an advocate at any time, advocate of justice, standing on her own feet, his own feet, and having own views, independent of mindset, not accepting any given idea without examining, without questioning the logic of it. I mean, that's the primary trait of a lawyer. Now that, yes, we want to make every student to be like that. But equipped with that technology, legal technology, what will this student do? Would that student act as the social engineer, architect of justice? So if you look at that idea, then I think there are not just court-based 6 or 12 types of legal careers as the officials of the court, as judges or as lawyers, as prosecutors. There are some more. And these some more could be legal reporters, legal researchers, legal technologists who will advise the forensics, etc. So we have identified not less than 24 different types of legal careers. Some of our students also become, as leadership is born in the law schools. And invariably, many leaders are lawyers. That doesn't mean every lawyer is a leader or every leader is a lawyer. Of course, every leader is an advocate of certain type of life view, world view. If you go to the strict definition of leadership, it's about the one who gives the view, world view, life view. That person is the leader. So law school is the crucible of producing leaders. Now, how far our teaching process, our learning process, our curriculum encourages this kind of personality trait, builds on that, nurtures it, is the question that you and I have to ask. So asking that question, I have moved on to identify certain types of avenues for lawyers. So some of our graduates, invariably, every year we produce 2 to 3 civil servants, IASs, IRSs. That means there is a very close relationship between governance and law. Some of them end up in company secretary, company services board, company law board. Some of them end up in hardcore civil service as the district commissioners. Now, IRSs, revenue commissioners. So my BBA LLB, BA LLB, both are capable of producing civil servants. On the other hand, because I give the orientation, on the other hand, many of them have become chartered accountants alongside being law graduates. Some have become company secretaries alongside, or tax consultants alongside law graduates. A few of them have become academics in Jindal and other places, even in Bangalore National Law School. Some have become so. Like Harvard, we also took an analysis. For all this, data is very important. We do the data analytics. So when we meet our alumni and discuss, when we see the growth trajectory of alumni, we see general spaces which our graduates have occupied from Symbiosis and other leading law schools. There's a very interesting phenomenon that you observe. For example, Delhi University has produced excellent law graduates. And these law graduates mostly are shining in public service as judges. Like Lokur sir is a classic example, Nandrajog sir, Chandrachud sir. Now, how we could produce such socially conscious lawyers from Delhi University? You know the reason. You have heard Dr. Pandey. So, these breed of teachers, if I can say, have inspired that kind of public service which built Indian judicial system to have its own signature internationally. Our judgments are now copied by many other countries, which are even mature democracies are looking up to our judgments. I was analyzing Supreme Court online, Supreme Court cases online, and there is a number of reference to it in Commonwealth jurisdiction to the judgments of Supreme Court. So how we have created that kind of impression, Justice Ravindra Bhatt, another product of Delhi University, his judgment on women's right to worship has been, I cited it in one article where we have analyzed the judicial track in terms of tradition and modernity polarities, and it has been picked up by Harvard Journal. Because such an innovative way of, without disturbing the social fabric, cultural fabric, incorporating the constitutional principles which Sir said, of gender equality. Similarly, in IP area also, a lot of judgments from Justice Bhatt have been considered as the most impacting judgments. Now, if you see the correlation between this kind of outcome and the teaching techniques and the law school approach, there is definitely a correlation. Now, that correlation is the one which should inspire our generation of teachers, your generation of teachers. So that is my introductory appeal. Now, how do students experience the delivery of legal services in the real world context is another question. How do they experience legal office environment? How do they understand the importance of clear communication, identification of client problems, and how do they tender effective and efficient advice? Because once you know there is a lawyer in the neighborhood, who said this, that if you are a lawyer, I think it is Benjamin Franklin, if you are a lawyer, then you are doing good to yourself, you are doing good to your neighbor, and you're doing good to your country. So once you are a lawyer, once you produce this kind of law graduate from your school, that kind of mission, that kind of larger role that person plays in the society is to be understood. Therefore, for that, these kinds of personality traits have to be cultivated. You have to understand how legal practice or profession operates. How do the professionals operate? Professional legal attitudes, ongoing process of professionalism, how to consolidate the professional legal training, how to, so this is what is the first part of what we have to produce from our law schools and how we orient our teaching learning process, our curriculum, our pedagogy, and our assessment as well. Unless you assess them, you won't know if your pedagogy, if your content has reached correctly. That's why course outcome and program outcome. Each course outcome you define, some courses may have certain knowledge outcome only, some courses will have a good mix, some courses will be exclusively skill courses. You know the clinical courses which Bar Council of India identified, the 4 courses. You can have a clinical component in other courses, nobody prohibits you from doing that. Then, coming to a closed door discussion as teachers and having millennials in this classroom, teaching the millennials is a very new challenge that all of us are facing because these millennials are busy with their gadgets. If anything, without the gadget, it doesn't interest them. Their attention span, I remember one of the younger faculty with the National Law School background yelling in the class, your attention span is of a fly. Means there is no attention span that you and I would have experienced hours together sitting in the library, hours together listening to teachers without complaining. Now that kind of attention span you don't expect. Millennials are very tech savvy. They will take to things if it is through technology. Millennials are, they have difficulty because they are usually single child or 2 children. So team behavior is missing in them sometimes. They may have difficulty in making friends or sticking with friends. That is why nowadays marriage also is under threat. Either they don't marry or they don't keep the marriage. So these kinds are, relationships and transitioning. It's not that it didn't exist in our times, but there is more frequency of, and you see the courts also behaving in the way of giving cognizance to such behavior. Because something you cannot change, you have to accept and move on. That is teacher's challenge. Then, how do we align the content pedagogy or delivery and assessment with the course outcome and program outcome which current NAC is expecting? So these are some of the questions that we have to ask. I must tell you that when we are looking at learning outcome, the taxonomy of learning, Bloom's taxonomy of learning, which education experts use as the Bible, talks about different domains which we have to cultivate in a student, which exists in every human being. And in the learning process, you have to refine them. That's what education is about. So in law field, mostly when we are talking about the cognitive domain of learning is something that we can see as to be associated with learning outcome. How do you create that ability to remember? In law, we have to remember a lot of sections. We have to remember the overview of the legislation. Understanding. Understanding is very important to apply the law as well as to interpret the law. Applying the law. Real life situation, how do you apply the law? Analyzing is important in what I already told in interpreting. Analyzing is also important to see, to arrive at a conclusion, and also to innovate, which is the next step, to evaluate, to appraise, to arrive at a conclusion. And the last one is to create the perspective, new perspective, or a treatise, or you may be also creating some kind of viewpoints which will become the building blocks for future thinking. You know, obiter dicta in a judgment becoming a hypothesis for the future judges to work with, or for the researchers. I hope these points are clear. So at each level, the student moves to a different direction. Suppose this is an institute which is offering undergraduate courses. It has got most of the courses till first and second year in the line of remembering, understanding. If it is law course, then it will go to the extent of applying. And if you are the institute which is encouraging research, then from first year itself you can give applying as well. Now for that you need different kind of pedagogy. You need different kind of teachers who are trained in that applying kind of orientation. And then you come to analyzing. In applying also there is a certain degree of analyzing, but analyzing could be volume of such cases being analyzed. Evaluating, where you may be asked to judge a particular type of case where there are competing evidences and competing legal viewpoints coming in. And creating. Now, we usually say in postgraduate courses or in honors courses, we come to that top 2 points of the ladder. When you are in the undergrad courses up to about honors courses, you may stop at the analyzing level. So inculcating that ability to evaluate and create is something that could become the signature of your law school if you are able to scientifically develop that, train your teachers, or if you teachers take the initiative to train yourself. We have so many trainings going on all over the country, and our Professor Subramanya is an eminent resource person and a leader in this. He has done so many such trainings in National Law School. Dr. Menon does. Look out for such opportunities. Ask your institute and go and attend these things. Now, if you are talking about, in the previous slide also, if you're talking about understanding and applying, some of our court visit exercises, some of our mooting exercises, if you're going to evaluating and analyzing some of our mock trial exercises, even in terms of understanding and applying, if you're taking your students to the prison, if you're taking your students through the community-based law reform exercises, you take them to the last level, evaluating and creating. Because first of all, you have to learn that issue in the society, which has not been addressed by the law. Secondly, you go and learn the law. What does the current law say? So you are taking them through understanding, applying, analyzing, evaluating. And then you see the gaps, and those gaps recommended for reform. And you recommend which part of the law, which section, or you may recommend a new act altogether which will address this issue. Now that is creating. So we see, if you are engaging students in law reform research, or engaging students in research to suggest or recommend change for the law based on community-based or stakeholder-based perception analysis, you are reaching them to the highest level. And there is another advantage for a university like you. It would be publication. So such publications cannot be ignored by any journal because they have very, very original viewpoint and they have methodological complexity. So that is a little selling point I could share with you. So when we are talking about learning domain, in law we mainly predominantly give students the cognitive domain which the Bloom's taxonomy has shown in those ladder steps, rungs of the ladder. In law, we also have two other dimensions. One is the physical dimension of skills. For example, taking notes when the client is talking to the lawyer. We usually encourage this by means of field work, psychomotor skills, or by means of internships, work placements, etc. Then effective learning, growing feelings. Sir was saying, the moment he sent his students to the prison or to the beggar research project, there was transformation in the student. What is that? Your heart's valve opens. Your emotional dimension of the personality grows. So that is the effective learning. Just look back and see how many of you are using cognitive dimensions in your teaching, assessment, or pedagogy. Just reflect. You would just reflect on his sheet. How many of you are using psychomotor skills in terms of field work, or internship is mandatory under the BCI regulations, college must be doing it, but how many of you engage with those students in evaluating their assessments? How many of you have seen that one of your assessment exercise is to go and talk to a client, or go and talk to a lawyer or a judge, or to a field where there is penury of poverty or crime-ridden or slum or any deprivation in the society, what Bakshi calls as human suffering? Have you diverted their attention to the human suffering? You know, because hitherto, the dimension of the law was about rights and interests. But if you're looking at developing world, more than rights and interests, it is those who have no rights and whose interests do not become visible in the law. So human suffering in the vulnerability that these people exhibit. So that is the angle that a law school in a country like India cannot ignore. So how far are our learning outcomes, our teaching tools, our knowledge, the cases that we discuss with students, literature, articles that we discuss, reflect on this is the question that you have to ask. Now, some of the scholars talk about skill and knowledge-based learning as skill versus knowledge-based learning, etc. So I argue that it is not versus. Skill and knowledge can be inclusive. They can be complementary to each other. What you learn, you apply. What you learn, you see acting in the real field. So for me, skills should be aligned with the competency that you expect out of your graduate to fit into or to pick from, choose from all those 24 careers that I was talking about, or the court-based careers or society-based careers. Now, there are versatile careers. You know, I am not here to list those careers, but I told you certain ideas I gave you. Now, the hard skills for any career, the mandatory skills that is required is research skill, analytical skill, spotting the issues in a given conflict situation, spotting the rules related to those issues. So here, you have to go in terms of thinking skills, multidimensional thinking, you know, out of the hat, out of the box kind of thinking sometimes, problem solving, decision science, which is about evidence appreciation, weighing the evidence, not deciding without evidence, and classifying the quality of evidence or data. Even in research, we have that. Not every data is relevant, classifying that data. And then leadership skill, which is, I told you, it's inevitable for a lawyer. Now, Baltimore school has identified certain skills, which is also endorsed by National Skills and Competency Councils of Australia, and Indian National Skills Metric also to some extent connects to this. But for lawyers in India, we don't have a separate psychometry or skills metric identified. But we can draw a lot of inference and inspiration from this, and we can incorporate it into our teaching handout. One is the observation skill. You can test it with the students. Communication skill, oral and writing, which you do by giving them assignments. You know, oral could be tested by mooting, it could be tested by paper presentation. Interviewing skill, you can have a live client brought to the class and or take them to the NGOs with the permission and all those research ethics being followed, and they will talk to the people who are housed in that NGO. Planning, counseling skill, negotiation skill, time management, which is one of the casualties in millennial generation. Whole night they'll be watching films from their laptop or nowadays from the palm top, and early morning they do not turn out on time. So time management is one skill which, if you punish or reward, is going to make a lot of difference to the law students. Cross-cultural competencies, ability to interact with people who are different from you. Maybe in a cosmopolitan place like Bangalore, it may not be an issue, but you can't take things for granted. People could have those kinds of inability to stretch the brain, stretch their personality. So we test it by assigning students as buddies to the international students, as buddies to the faculty who come, guest faculty. So some such skills you have to test. Emotional sensitivity, which we test by community project. Teamwork, giving them group assignments, and you spell out the criteria of assessment. Managing conflicts, how far students have the ability to manage conflicts. Problem solving skills, ability to pick the non-verbal cue when the client or when there is a problem. Delegation skills, calculated risk taking, and one of the important skills is saying no sometimes, you know. It could be an ethical situation or it could be something which you don't have competence for. You should not take on yourself something which you cannot fulfill. So with that in the background, this is a general tip for a law teacher. I come to this part of my sharing with you. and that is criminal law administration or criminal justice administration in the context of law teacher or instructor. I say that the primary expectation of criminal law teacher or instructor is to set, facilitate, and raise critical thinking. What is this critical thinking? Evaluative mindset, not accepting anything as given, examining, interrogating, inquiring, doing more research, and then coming to a conclusion. Now, if you want to look at your own students, you have to ask these questions. What do they want to learn? What do they want to do? And how do they learn? So if you see students, they may not want to learn only from books. They would respond well if you give them multimedia, because I told you, millennial generation we are dealing with. So not everything, but at least some portion of that could make teaching interesting. Because one of the problems why students veer away from the law school or don't perform or don't match in terms of their performance is because they don't like the teaching. Why they don't like the teaching? Because teaching is not made interesting. It's not reached to them. So how do you make your teaching interesting? You make teaching interesting when it resonates with them. So it is believed that with the millennial generation, what resonates is multimedia being brought in, or experiential learning component being brought in, team behavior being brought in. It helps them also. So unpacking oneself also is very important. For example, in my own case, if I'm unpacking my own role, I have, as a student itself, I used to engage in activist legal work. So we used to intervene in cases. Many cases used to be brought to my village home. I would bring it to college, work with fellow students and teachers. We had one Rodriguez, he is no more. He was the minister of Karnataka government, and the next day of losing the ministry, he would be walking the streets of Bangalore, coming to college, teaching and doing his legal work. So he has never taken fees in all those cases which we took of the poor people, and he used to advise. So we used to make interventions. I was also part of the reform body, as it was told. So we were dealing with honor killing legislation. Should honor killing be treated under criminal law? If it is to be treated, is it only an amendment or should there be a separate bill? This debate was there. Honor killing could not be taken as a part of a provision of 302 because it was always followed by an unlawful assembly. So unless you make a drastic change in combining provisions of the Macaulay's Code, it couldn't be tackled that way. So there was a separate bill created to tackle honor killing. Similarly, 498A. When 498A was debated in our law commission to be scrapped, I had to do the entire resistance because I was the single woman member on the commission, and I had fortunately two senior Supreme Court lawyers who were trained under Dr. Menon's care, who were vehemently supporting. So we had a house of 10, of which only 3 were against it. Finally, we were able to get the support of 7, who agreed with one caveat that there should be guidelines to the police against indiscriminate arrests. So this is how that whole negotiation is something that comes. If you have a critical thinking, you have that kind of background. Now, coming to the system context, sir was talking about many contemporary developments in relation to states' overuse and Malimat committee's exhumation or revival. Now, main thing that criminal law's objective in terms of serving is right to security. I think in any state or any organized society, right to security is the first right which will ensure human happiness and realization of other rights. It is criminal law and criminal justice administration which plays a primary role in that right to security. We have these kinds of new developments which are coming, like date rapes, where there is consent, but the consent is not to rape you, you know. So this kind of twisted kind of situations which are coming up. Media interventions in every case, as sir rightly pointed out. Political killings, trolling, which is a new phenomenon because of the technology use, hate crimes which are being abetted as well as committed. So there are new challenges to the system. Now, how does a law teacher incorporate these challenges into the curriculum or into the development? Let me give it to you once we put these points in perspective. Now, what is the kind of justice perspective that you are going to inculcate in students? Ordinary person on the street would take very strong positions. Should our students take those strong positions? No, they should take informed positions, critical positions, sometimes inconclusive as well, saying, let us see, let the research be showing it. You know, these kinds of learned, informed insights students should have. So, do we encourage retributive kind of approach or distributive justice kind of approach? You know, the study of Delhi National Law School pointing out how majority of the criminals on death row come from very, very poor, vulnerable backgrounds. Now, what is the kind of distributive dimension which is, sir was talking about equality clauses clashing. Retributive approach is where people were very happy that Memon was hanged, midnight Supreme Court hearing was. Now, that approach might blind us to what was told, the constitutional context and the human rights context. So, for me, the core dimension that has to be ingrained is the justice dimension. And it should be the dimension of what sir said, the harm principle. So, do no harm even in administration of justice. So, can we negotiate between choices? Can we plan well? Can we act well? Can we resolve well? Is it to criminalize or decriminalize? That is also a debate. You know, should we criminalize everything and believe that harshness of criminal law is going to deal with the problem? You know, like sir was telling about rape and death sentence, as if death sentence is a panacea for all evils, you know. And the negative side of death sentence, studies show that severity of punishment is no guarantee of non-recurrence of a crime. So is it severity of punishment? What is a negative effect it could unleash? Now look at the increasing rate of killing after rape after death sentence was being advocated in case of rape. Have you seen these news items? Do the analysis and you see. So hitherto it was rape and rape survivor, and redemption of that survivor is rehabilitative dimension, and reformative dimension or retributive dimension, punitive dimension in case of the accused. But today it is much more. Now, what about the other factors which are causing the increase in the rape? Is there any integrated approach to that being taken up? For example, preventing. China has declared its own Google. Why? Because of the impact of the content which is available even on the cheapest mobile phone, right? So this is one. So should we look at criminal law as standalone or cross-sectional? Sir has identified many dimensions. I would also say jurisprudence is one dimension you have to deeply analyze. The very idea of intention, malice, motive, their interrelationship. Any one of you is clear about Salmon's jurisprudence on these three dimensions within the idea of mens rea? So you would agree with me that there are deeper nuances which need to be studied, and learning the judgments from this point of view also is interesting. Second is forensics. Third is constitution. Sir already highlighted, I don't want to highlight, human rights. Now, as teachers, one of my colleagues in Hyderabad Law School, he had evolved a method of, he's a forensic expert who had been in the police before he took to LLM and forensics. So he did a very nice forensic stand kind of concept, actual murder happening, and then the body laying there, and then how the body was found, how the examination was done, how it was being used as evidence. So expert evidence, expert witness dimension being tracked back, you know, reverse engineering of the whole concept. So you can learn it by creating a scene in this space which you have in the campus. So that's a very good way of learning, and even students of other discipline can take interest, because appreciation of evidence is the basic skill in arriving at any conclusion. So that is something law can contribute to other disciplines. I want to bring to your attention one dimension which is not mentioned here, the interdisciplinary dimension. I don't know how many of you have studied. We always have economic offenses. For me, every offense is economics. Why? Today's Times of India carried a report I want to share with you. Reduce domestic violence and it will unleash an economic bonanza with thousands of crores. Now, this is the research which is coming from Tata Trust, which is intervening in villages in educating women to not to become victims of domestic violence, but to negotiate their lives by proper participation in training, economic independence, and legal rights awareness. Now, to arrive at this kind of a project, they did a research, and global research, especially the model which was developed in Uganda, was used by them in a test village. They are telling, it's an entire article, please go and read in Times of India on op-ed page. I'll just read the highlight. Globally, violence between intimate partners costs the world 25 times more than all wars and terrorism. So have we seen the cost of violence? Why did Buddha say non-violent? Why did Gandhi say non-violence? These were not simply absurd philosophies. See the relevance. You prevent one criminal behavior, so the entire thrust is on behavioral modification. That behavioral modification from the psychological, so it is interdisciplinary analysis. So it's not just crime prevention, it is also reducing the impact of crime on the society. So this is a new dimension that is emerging. In South Africa also they have done a study. I'll just give you Andhra Pradesh highlight. In Andhra Pradesh, reaching 17 lakh women for a cost of 164 crore. Of these 17 lakh women, more than 5 lakh would be assaulted by a spouse annually. Based on the studies in India and abroad, it is likely each will, on an average, experience abuse 8 times a year. Let me quote, Rajasthan's domestic violence rate is much lower, so the benefits would be less considerable, but remaining compelling. The cost of domestic violence to Rajasthan in 2018 was a whopping 8,200 crore. And targeting 19 lakh women would help 2 lakh women avoid abuse. Leading benefits were 2,360 crores. So avoidance of domestic violence, what kind of economic impact is there? So I was also very heartened to read this news item because my economic analysis of law understanding was always on IP. It was always on something like economic crimes or something on taxation law, which is directly about money. But have you ever realized the cost of the crime? Look at the communal violence or communal riots-ridden places. How they take very long time to revive and the property rates going down and style of life being affected. So it's not a standalone discipline. So therefore, while training, it's not just narrow professional training. We may prepare some law students to be social workers, running NGOs, becoming leaders, opinion leaders. So crime is as instrument of social control and governance. Criminal justice administration and criminal law as instrument of social control and governance. Have you seen that dimension? Have you taught that dimension? So it's very important. And Sir's exposition would have highlighted the deeper layers in terms of constitutionality. Now your context is also about the process. Mapping or marking through investigation. I gave you the example of my colleague Dr. Stanley's approach. Prosecution, mapping prosecution, like once I was dealing with the dowry violence case and I realized how the prosecution plays a key role in bringing to books. My friend being a prosecutor there made a lot of difference in the case which I was handling. And then the director of prosecutions was resisting and I had to go and convince that person. So prosecution plays a very key role. The media. Judiciary. We used media also as a strategy to inform the public whether this case was being given up or it was going to continue. Judiciary, post-conviction, and the role of public. So you take a case or you take examples, you take media clippings and probe into that. They could be part of the assignment as well in the class. Did you realize that today's newspaper would have made my teaching content? So every one of you will have something which will make the part of your teaching content and it will bring students closer to you. Take the case of women or children or third gender. How they are vulnerable to bias, not only by the community, but also by the judicial system. Carol Smart, this British author, celebrated British author on criminal law and gender justice, talks about how battered women were viewed as mad women in the court, and they were viewed with bias. It was, grave and sudden provocation exception was taken, so the punishment was reduced, but the approach to these women was of disgust. Anybody who is into Kannada literature here? Have you read this prize-winning novel by Chaduranga, The Mrigaya? It is about Judge's own inward journey when he is looking at the battered woman who ends up killing her husband. So the entire battered woman syndrome came to be reckoned as a mental health dimension because constant exposure to violence leading to personality change and making people indulge in sudden crimes of passion. You know, the same person who was once loving becomes a murderer. Why does it happen? So mental health probing started with this kind of awareness. Professor Ratna Kapoor also talks about subversive site, law as a subversive site in terms of gender justice, and how in rape cases or rape trial, equality becomes male objective norm. In fact, it is a subjective norm, because she says the probing into the character of the accused and probing into the character of the survivor are the way in which they are pitted against each other. Although we have an amendment now, the bias is still something that could give an advantage in the evidence process. Public hearing, which was conducted in Karnataka by Vimochana non-governmental organization in case of unnatural death registers, was also a very good case study. National Law School students actively participated. So encouraging such public hearing through NGOs and engaging your students to conduct and organize is also a very good exercise for pedagogy and assessment. Then we can look at citizens' rights. We can look at extra-legal method, extrajudicial killing, which Sir talked about, the incarceration risks in certain communities, overcrowded jails. This has been a perennial problem. I was reading about Brazil the other day. You know, the burning of prisoners which happened, the fire. We had overcrowded jails in Erwada, resulting in prisoner killing the other prisoner, psychologically disturbed prisoner. Despite that, he was not isolated, he was not specially treated. So we made intervention, but the legal aid was not forthcoming. So all these kinds of issues exist in Indian jails. So if you can start your prison clinic, nothing like it, you know. I do not know if you are already engaged. It's possible by having meetings and then developing a framework. We will be very happy to share our framework. Learning and relearning through the community-based law reform is a good exercise, which I already told you about. Clinical learning, where you incorporate as part of your learning. For example, criminal procedure code. Instead of a teacher coming and teaching the codes all by herself or himself with the help of cases alone, they should be there. You give them a mock trial and you bring them forms and formats and run through the life cycle of a case in terms of stages of a criminal trial and correlate the procedure. That's a better way of learning, and students do extremely well in exam, and many of them develop interest in litigation. Moot court is another way, appellate argumentation, rehearsals. Lab visits, forensic lab visits, we constitute that as part of the assessment. Court visits, police station internships, prison clinics, and simulation of judgment or criminal trial, or simulation of forensic investigation. We sometimes get inspiration from the way in which judicial academies train judges, you know. So how do they train the subordinate court judges, the magistrates? Some of those trainers can come here. Some of those training methods you can adopt by duly honoring them. So some of the teachers can take initiative, which I am sure Dean will be very happy to encourage. Teaching criminal law through case method. So ideally, a good law teacher is an entrepreneur. You have to discover your own way of selling the course and making it interesting for students. So you are an intellectual entrepreneur. So discover that power as the teacher and engage in teaching. Now, teaching criminal law through case method is something that is most interesting and is the focus of my discussion with you. I can go on for a whole day, but I'm told I should restrict to this dimension in depth. So far we have done a wide spread of menu, but this is going to be a little in depth. So what are the different methods? There are many methods of teaching, as I highlighted. So I'm just listing as a summary. Case method, the problem method, role-playing method. I hope all of you are aware of this. The multimedia method. Anyone has watched Rashomon? Yes, not many. What is Rashomon about? You can tell the class. It's a Japanese movie of Nobel laureate Akira Kurosawa. And in this movie, there is a murder of a person. And the recasting of that murder by various witnesses is so inconsistent with each other. So it is what the blind man touching elephant kind of Upanishadic story. It's like, you know, the mosaic of truth, how different pieces of puzzle piece together to construct a truth, and it appears that everybody is giving different version of truth. So this is how we have this adversarial system of justice. Witness statement, the way in which witness statement defeats the case. And hostile witness is one issue, inconsistency in the statement, generating the benefit of doubt and lowering the rate of conviction. So it's here that the students will be able to see the testimony of oral evidence being subject to certain risk of or becoming a casualty, truth becoming a casualty or truth becoming difficult to educe. Do Aankhe Bara Haath is also supposed to be one such, this one. I have not gone through the movie, but I know about the movie. Talwar, sir was talking about the Arushi Talwar case. Talwar film, how close it is to the real case. Does it make judgment? And what happens to the movie in the new context of CBI's case being thrown away by the court? So this is how. You simply don't show the movie or ask them to see and come. You generate questions. You connect it to the concept that you want to drill into their mind. So they would learn better when you give it in that familiar situation. Always teachers' way of keeping the interest is by taking from the known to the unknown, using the known gateway to take them into interesting exploratory journey into the concepts and into the knowledge. So how we can use short documentaries, Nuremberg trial, for example, short films, long films, and then generate question. To generate question, you have to see that film. You have to see it analytically. You have to correlate what you want to teach in the context of the film. So each one of you please discover this kind of original way of using. Drafting documents could be a skill. For example, how will you, X comes to you, that she has undergone some kind of criminal treatment at the hands of someone. How will you draft the complaint to the police? How your complaint gets infused into the first information report. So these kinds of things, or bail petition, yeah. And modeling. You can model many things. One model, I told you, the forensic model. You can have a court model. You can have lawyer-client model. Live client can be brought to the court, class. Out of class, like we brought one inmate from Yerawada prison to the class, double MA, ended up killing his own brother, and the situation of the business, etc. He was supposed to be the caretaker of Sanjay Dutt when he was in Yerawada. So he became a glamorous kind of companion to Sanjay Dutt. So students took a lot of interest in that. And he was extremely fluent, and he was talking to the class and revealing his experience and revealing the crime situation, recounting. Of course, with proper psychiatric monitoring, you have to do that, because then they can go out of control also. Out of class and online teaching kind of experience. Out of class teaching, I take them to the prison and then I teach them some dimension of human rights under the tree where Ambedkar and Gandhi had signed the Pune Pact. That becomes so interesting for them. So it is not just sitting under the tree, but they are also learning something. So whether you can try such things. Online teaching, online materials, now Swayam platform, sir was telling, VC sir was saying, whether some material from there could be used. From YouTube, could you take some material and use it as part of the class? Not completely saying that that is the gospel truth, because a lot of web resources need verification. Creating study groups among students, journal reading groups, team activities, tutoring them. What is the difference between teaching and tutoring? Tutoring is a digestive part of the teaching. One dimension, maybe one case, and one section, and that case with the help of 5 questions can be put to a tutorial in a group of 8 or 9 students or 12 students, maximum 12. And then it would go in circles and they would answer the question, they would raise questions, and you are there. Ideally, we appoint learner teachers or research scholars as tutors, but I also tell you, the teacher also should be a tutor to one group. And teacher should prepare the handout. Then only you know how you can simplify your teaching and where you have gone wrong in your lecture. Reviewing, case review, article review, writing the gist of the article. And then we always use the teaching ethics approach, because ethics is about journey. So we engage in debates, discussions. We had this famous Queen versus Dudley and Stevenson case. All of you know about it. A case which passes on in the tort as well as crime. Now, Speluncean Explorer, we created a hypothetical case out of it in Ireland, which Twining and Meyer's book talks about. In that, you would be the 4 judges. One judge who would strictly interpret the letter of the law. Second judge who would go behind the purpose behind the law. So, literal interpretation, purposive interpretation, literal purposive, hybrid variety of interpretation. Then exceptional, you're taking the exception out of the rule and interpreting the rule. So within the rule, taking exception, or literally applying the rule, or going behind the intention of the rule. So these kinds of purposive and literal interpretation, once again taking one step further while interpreting the case, how would it alter the decision? Whether cannibalism is something that is to be hated as a crime against humanity, therefore strong position you take. So you can even connect the theories of punishment to this. So this is how the concept is drilled into the minds of the students, which will train them as lawyers, as judges, as being empathetic client counselors. Now case method. How do you do the case method and why the case method? How do you do the case method? I have given a YouTube link, 2 links which you can see, but I'll take one case and show you. Why the case method? The case method, when you use cases from the court and you discuss it in the class and you go through the journey of the judge's mind, or you make students to judge the case by giving the facts of that case and making them write a petition or memo, student is at the center. Student is doing something, discovering the facts, connecting theories. Teacher is not the sage on the stage. Student also participates as a sage with the sage. Active learning by the student. There will be interpersonal skills where the student debates with the other student. There will be team skills where they all sit together and brainstorm. There will be application of what they have learned. There will be response to learning. They'll be responding to learning. They're not just, unilateral absorbers like a tape machine. There will be relevance to what they have learned in theory in terms of this real life situation in the case. There will be feedback which the student gives. It improves the student learning at different levels, cognitive level, psychomotor level, we spoke about affective level. Making informed decisions, students will be able to derive that process of decision making, and they will be able to recognize the ambiguity or complexity or logical flaw in the decision. So you can't do the case analysis unless you read the case at least 5 times. So this method is called IRAC method, IRAC method. How many of you are familiar with this method? Anybody is familiar? Yeah, 1 student, 2, 3. What is IRAC? Issue, rule, analysis, and conclusion. So in the analysis and conclusion part, lot of work is there, particularly in the analysis part. In the facts part, also you have lot of work, absorbing the story, picking the relevant fact. One of the celebrated teachers of Delhi University, I was told, used to say, it's like the process of taking butter out of curd. When it turns into buttermilk and each grain of butter accumulates, So like that, you have to sift the relevant fact from the irrelevant fact, and not to miss the important data like the date, the timing, the other relevant data. So first thing is looking at the brief of the case, and then doing the anatomy of the case. The case is divided into its head, its hands, its legs, and then you try to see in those facts which rule will connect to those facts. So you have to discover the rule. Rule may not be found in one book or one legislation. You have to connect the legislation. Once you discover the legislation, you see the interpretation of that legislation through the previous cases, because we are common law, precedents. And you can also impress upon new way of interpreting. Sir was saying, why didn't the earlier human rights lawyer look at Article 14 or Article 13? Why didn't they see? I always argue with judges, is it the suo motu initiative of the judge about the finding the law, or should the judge restrict to the brief that is given by lawyers? So these questions also you can raise in the class. And then the conclusion that the judges have drawn. If you are giving a fact situation, then the conclusion that the student draws. Mind you, in law, any conclusion is right. Tomorrow you may be defense lawyer, you may be prosecutor as a student. So your mind should be able to operate on both lines. Any conclusion is right, but what is important is how you justify your conclusion, how you derive that conclusion. So don't discourage students, don't antagonize students when they don't agree with your train of thought. You have to respect the diversity of thought process, facilitate them to think correctly, not that and think stretching their mind. So within the judgment, when you are applying the IRAC analysis method, you are looking at the holding or the conclusion of the judge in favor of the defendant or the plaintiff. What does the judge give as the reason? And in that reasoning, if you go by the Wamba test, you know, in your Rupert Cross precedence analysis, the part of the case which is having, part of the judgment which is having correlation to the rule and the fact, most important fact is the most important holding. So we do pyramidally the holding in the judgment, most important fact, second important fact, third important fact or issue. And then, by the way, judge makes certain observation. For example, Sarla Mudgal case. Judge spoke about the remedy available to these women, but at the end spoke about uniform civil code. So an observation passed, by the way, the obiter dicta is also very important when you write your conclusion. So is that clear to you? All of you? Yeah. Now, we give you a case and you should be able to write the IRAC analysis. So when you are using, it is not just a linear judgment. It's not a linear analysis. It is an interpretation technique and it is also a skill. Therefore, as teachers, you have to understand that your curriculum is a learning contract with the students. Therefore, always integrate theory and cases. So this slide, I'll just give that connection. Now let us learn the IRAC method. First you cover the issues and rules and then application and conclusion, and read the statute also. Reading the statute also is very, very important. So after you read the statute, again you read the full case, read the rules, and then write the analysis. You can do it in a group or you can do it individually. I always take this case, very interesting case, because there is an animal involved there, which seems to be very friendly to human beings. So it makes it very curious for all of you. There was one organization called Koala Care. Koala is an animal which is like the panda, which is a tree dweller, arboreal animal. Somebody caught him from the forest, and then he seems to have been rescued from some hunters. So there were some injuries as well. But he was very friendly and he would eat from somebody's hand. So this person, which is the rescue organization, a corporate, we can say, or NGO, Koala Care, rescues this koala and keeps the koala. After 3 days, the koala escapes. It's a wild animal, it will escape. Its behavior is just like our students' behavior. So in 3 days, it escapes. And then a citizen captures this. And citizen cannot keep it in the house. It's rarely a baby. So he gives it to a private zoo. Now, who is the rightful owner of the koala? This may not be criminal law dimension, but there is one dimension of criminal law which comes here. What is an animal? Is it an immovable property or a movable property? How many of you say it is immovable property? Nobody. It's a movable property. Animal is, in English concept, it is coming within the idea of chattel, right? Yeah. You remember your reading. So, which crime relates to movable property? Which set of crimes? Trespass. Movable property, recall. Theft. What other? Extortion, dacoity, robbery. So all these. So just keep it in mind. I should not be giving the clue. You are supposed to discover. But I'm just trying to reduce the time to think. So what type of tort claim, if you are looking at tort? In our case, I mean, does Koala Care organization have a claim? If, let us just twist these facts. There is some criminal behavior involved here, let us imagine. He finds this koala. He also finds the collar where Koala Care's name is written. Still he goes and gives it to a private zoo for thousands of rupees. Removes that collar. So let me twist the facts. Does it come in the purview of criminal law? Does it come? Can a finder keep the goods? Finder keeper. Quasi-contract. He has the obligation to find the real owner. Now in this case, let us twist the fact that he has got a collar. The koala has a collar, and in the collar, Koala Care's name is written. He cuts that, and then he knows that private zoo is happily taking all these exotic animals, and it will pay thousands of rupees or lakhs of rupees. So he goes and hands it over, take that money. Let us say in Indian context, it gets further complex by cash dealing. So all these facts, so twist this. Same case can qualify as crime and tort. Not all, but some, that. Nuisance could be. How does it qualify as crime? The moment there is malice coming in, motive coming in, design coming in. So cutting of the collar is a design, right? And the motive is the money that he is getting. The malice is to deprive the owner. There may not be direct malice, but the malice is to interfere with the right of the rightful owner. So, what kind of claim, a tort claim the Koila Care has, if you're talking about compensation, what kind of remedy or what kind of action can Koila Care take in this context? Now, you can twist the exercise to suit a tort or a claim or a contract. Same set of facts. So if you're doing this, first of all, you are breaking the given rule. Now here in tort, we are using the Rip-Levin rule. In case of crime, let us use the rule of misappropriation. Misappropriation of property. Or it cannot be theft because it was not in anybody's possession. It was found there, right? So misappropriation. What is the crime of misappropriation? Can anyone tell me? Anybody has IPC? Yeah? Full, yeah. Converting a movable property into your own use. So it is interference with the lawful owner. And it is not just ownership alone, but when you interfere with ownership, it also interferes with possession to some degree, not to all degree. Now, misappropriation is very closely bordering on finder-keeper relationship, which is a quasi-contractual relationship otherwise. So it's a situation. See, this is where your jurisprudence knowledge comes in. I hope all of you will be traveling with me when I'm talking it. So, on the left-hand side, if we are taking this tort case of rightful owner of unique and identifiable personal property is entitled to return, that is a remedy, Rip-Levin, from one who has wrongfully taken possession. Okay? So that is the right. So when the right is violated, it is tort. Now, let us view it from the point of view of the person who has given the coil. A person who wrongfully takes possession and interferes with the rightful owner commits the crime of misappropriation. So if you are viewing that, you break the rule. Who is the person who is committing the crime here? What are the ingredients of the crime? Who is this, who is the wrongdoer is that, okay? And then what is the subject against which misappropriation has been committed? What action must be taken by whom? So in criminal law, what kind of malice or malady has to be put an end to, and who should take the action? And we don't say what is the remedy, what is the punishment? What is the punishment under Indian Penal Code? Or what is the punishment in that law where this has been committed? Now we have separate laws as well for different crimes. So under those laws also punishments can be prescribed. Now today we have, I was reading about transboundary movement of hazardous goods. Now if there is transboundary movement of hazardous goods, is that a crime or is that a trade? Or is that, it's an international activity which is happening in the form of mutual consent by states, through the mutual consent only. But can it border on crime? If, as it is a hazardous good, why should anybody allow the movement? Should there be a strict ban? These are the debates which are happening. Now in hazardous goods, there is a very strong criminal law dimension. Now that is where environmental crimes come in. I don't know if you have connected your criminal law teaching into environmental crime. If you cannot directly connect, you can at least have a situation which is given to the students whereby you can bring in the environmental crime dimension and connect it to various Indian Penal Code listed crime and punishment dimension. So in this case, a tort law case which can also be viewed from the criminal law point of view. In tort law case, the person who has lost the animal is seeking remedy in the form of reclaiming the possession of the animal. If the animal is dead, ill and dead, then the person has the right to be compensated. In this case, it is an organization. In case of criminal law, the person who has interfered with that ownership, rightful ownership, is the one who can make the interferer punished. by invoking the authorities through the criminal law, by police complaint and the police going and investigating and finding if it was a kind of, if there was a malicious intention and the modus operandi, and all the facts will bring into books if the person is guilty or not, and then it will go to the court. So this is how it is done. So what are the questions that court must resolve in this case? If it is a tort, the question that is to be resolved is return and compensation. If it is crime, the question that is resolved is under which section is this a crime? How is this crime defined? So the ingredients of the crime and the facts will have to be matched as per that section. This is where R comes in. So issues and R. What are the governing principles related to the issue? So the issue that is to be resolved is there a crime? If yes, what is the punishment and what is the course of action to be taken to bring it to books? Now, how do the rules apply to the fact? Is there a movable property? Is it being misappropriated? Is it being converted into someone's ownership? Is there an interference with the ownership? So that is the analysis that you have to do, looking at the facts and looking at the rule. That connecting analysis based on previous case laws, based on the interpretative dimensions of the decisions, is what is done in the analysis. And then the conclusion. When you are doing it, it is the analysis. When already a judge has done in the Koala Care case, you are doing the anatomy of that decision and showing what is the holding of the judge, why, and what are the impact that is expected out of this judgment for future, how it will change if the fact was of this type. So that is a critical comment that you make at the end. I hope the IRAC analysis dimension is clear to all of you. Yeah. Now you pick a judgment like the Selvi case, or you pick a judgment which is normal judgment, and then you start doing the IRAC analysis in splitting it into issues, splitting it into rules. It is already done as summary for you in the case notes in Manupatra or SCC online, but you try to do little in-depth in terms of judge's logic and the way in which the fact has been appreciated and the ambiguity, if any, and the values, if any. For example, human rights or constitutionality, which we discussed, or the diversity, etc. So when we are investigating the rules, usually we have to look at the sources of the rules. Which are the sources of the rules? Case laws, statutes, ordinances or regulations, if any, customary law, if any. And secondary sources could be writings of the jurists or non-governmental authors. So once again, the checklist in case of criminal law is who is involved, who suffered, how, was it avoidable, what is the known information, is there any missing information, what are the specific details like date, monetary figure, what is wrong, with whom, seeing it from rules perspective, and how do you resolve this case in terms of previous cases, acts, legal principles. For example, Donoghue versus Stevenson case. If you are looking at Donoghue versus Stevenson case, it's about the ginger beer bottle in which the remains of the snail were found and she gets sick. Now from there we begin the principle of consumer protection. Now, what if that bottle was opaque and it was able to be seen on the preliminary examination? Would anybody make that kind of preliminary examination? Is there a bond of good faith between the restaurant and the consumer is one issue. Second is that it is said that shake well before use or examine before use. So is there a kind of protection for the seller because of that instruction that is given? What we call caveat emptor, isn't it? Buyer beware. And when you apply the same kind of set of facts, in the next case, which is that Grant versus Australian Knitting Mills case, what happens in that? Dermatitis is developed because of the dye which is used in an undergarment, which was used by the customer. Now there, is it that a case that the dye was a harmful dye by itself, or is it that some people are sensitive to that harmful dye? Was there enough of test done, lab test done before putting it into the market and sale? And what is the gravity compared to Donoghue versus Stevenson? Donoghue versus Stevenson was consumable item. This was an external use item. So as a judge, when you are awarding compensation, how do you distinguish the two? Similarly, in crime, someone who commits murder, Someone who commits murder with the premeditated intention to swallow the property or to do away with the enemy, or somebody who commits murder after being a lawful wife, loyal wife, serving this man who daily hits and belittles and subjects to multiple dimensions of violence, wants to see a dead end to that and murders. So, sentencing guideline dimension, the Sir said, principle of proportionality, the guilt being proportional to, or punishment being proportional to the extent of the guilt, by probing into the malice, motive, and the design or the intention with which the act is committed. So this kind of probing in rules governing resolution in terms of legal principles and analysis in terms of application to each party's claim and the contentious part, which needs to be further probed by expert witness and evidences, and then concluding which is the strongest argument. It is not the best argument. Between the two, which is the strongest argument? And then fixing the liability, whether criminal liability or civil liability. And how it could have been avoided, how such an act would have been avoided is also the probing that you have to do. Now that is where logical reasoning and framework of judges' thinking becomes important. Now at the end, I would like to bring to your attention certain critical facets. Always you see the outcome in a case, how it could be twisted if a particular fact is twisted. So when you are examining students, always try to twist the fact or mix the facts of few cases. Reading with the law of evidence, we have some course called, in legal reasoning courses, we have a course called referencing and linking and hyperlinking course. We take certain classical decisions and we see as the word appears, as the provision appears, we journey into that legislation. For example, there is a case where there is a crime involved, there is also a reference to constitutional law, there is a reference to international human rights law. We take the student through that journey. This kind of linking and hyperlinking and this kind of connection to evidence law and procedural law like CrPc or IPC, the substantive law, we look at that. I had a very interesting case in my student days which I had observed. There was a murder case trial that was happening. The murder happened in a village setting where the two adjoining property owners had enmity for a very long time, and one ends up slitting the throat of the other with a sickle. So in the adjoining band of the field, on the palm tree, some toddy tapper was tapping toddy at that time. So toddy tapper views this and he comes as the eyewitness. Now, is there a chance of anybody getting, any possibility of such live, direct witness going wrong? Absolutely not. But a skillful criminal lawyer, a defense lawyer, what he does, he goes and checks, measures the distance, and he sees the height of the tree, etc. So there was no way of protecting his client. But what he saw was, this witness was, people are very interested in judicial processes. And in villages, it is very rampant. There are many people, we call them foot lawyery, because they spend 8 hours in a day in the court. It is just an vicarious pleasure they take by watching what's happening in the court. And they come and discuss in the village. It provides a lot of substance. So this gentleman used to come attend the case on regular basis. And one day he sees this criminal lawyer, of course very impressionable kind of lawyer, good orator, etc. So he was very impressed with this lawyer. So he went and he looked at him and he said, Namaskar, So lawyer immediately got the idea. The idea is that this person is suffering from some kind of eyesight problem. So what he does is the entire cross-examination was about his capacity to view the exactitude of anything from certain distance. So the farsightedness of the person was taken as advantage, and you can imagine the accused got acquitted. So the crucial direct witness was played around because of the presence of mind of the lawyer. You will get such 100 stories if you go to the court of law. This was something that I had gleaned from my first-hand experience. Second experience was when I witnessed a young 12th standard student being stood as the accused. He was going to the college and a gentleman comes from the opposite side and hits him without any provocation. This child was going to the college as routine. Now he was drunk, the person on the other side was drunk. So when someone hits you, without any provocation and unexpectedly, what do? You resist, right? You hit back or you try to push the person. The case was filed under SCST, Prevention of Atrocities Act against this child. So straight away, no bail, nothing. He was straight away in the college clothes only. He was taken by the police, because this was all staged. You could imagine. Otherwise, how could the police be there in that spot? How could anybody report? How could this happen? So the defense was the father was shattered. He was in the court and I could see him in tears and all of that. And the next thing is the intention behind it. Once again, the property issue. So, the village mentality in terms, or these property kind of disputes, they can connect to crime in any manner. That's why I'm again telling economics of crime or economic circumstances of the crime, aside from the benefits of tackling a crime economically, are something that you cannot ignore. The complexity behind a crime is social, cultural, economic. Now, the boy was defended very well later on, but the few days he would have spent in the prison, you can just imagine the trauma that child would have gone through for no fault of his, except that his father was the owner of a big property. So this is how you learn a lot of different realities in the court. So you collect those stories or make your students go and collect those stories, have good network of lawyers, friends informing you, and this is how you become a teacher entrepreneur. Human rights considerations, mental health and menstruation, I gave you the example. I hope I have opened up many dimensions for you to make your criminal law teaching interesting. Please don't miss the provisions. Please don't miss the case laws. Encouraging your students to read more. Mind you, the students, as Sir was saying in his Beggars Project or prison projects, the students are with him. The students who were with me for community-based law reform project, which we did on gender equality of agrarian worker women under the aegis of National Law School and International Development Society, the 12 students today, one is working in British Council, 2 ladies have become independent lawyers, very, very successful financially and as lawyers in the civil litigation. One lawyer became the State Bar Association president, Bar Council president at a youngest age. Many of them, one is the British Council in charge in Dubai. So the kind of competencies they developed by doing people-based research and studies when they were in 3rd year and 4th year of law is something that shows that being a good law student is not just about scoring marks. It is about all those 3 types of competencies which taxonomy of learning highlights. So see that as students you cultivate that full round personality, see that as teachers you encourage that. But I tell you, unless the students also take the initiative, it's very difficult for the teachers. Why my all 80 in that batch did not become so successful? Why only 10? Because they survived the rigor of doing that project for 1 year. They went in the boat to a village which was in a kind of little island in the thick of the monsoon, stayed with them, without toilets, without proper food, and ate whatever was available, wore clothes like them. They were in the field, undergoing the suffering. Now that has made them very resilient to tackle the future evil, which is again there in one of the articles today, the uncertainty, ambiguity. Dealing with the uncertainty is cultivated. So with all these cores also, if you don't have that resilience to deal with uncertainty, it's not possible. Look at that lawyer who knew it was a lost case, but did not give up his optimism and presence of mind to pick up the eyesight problem in the client. So, in discussing sentencing also, you will have to do, like O.J. Simpson trial, the way media discusses and the way criminal lawyer discusses or criminal law teacher discusses will be very different. The political element. See, when you have very adverse environment in the court, how can you expect the case to be going in an objective way? That's what Sir was also mentioning. Like I had cases of girls becoming victims of eve teasing. When the girl is brought to the court, the way in which the court is treating her, first thing this girl does is cry profusely standing in the witness box, so we as NGO, we were telling her, okay, cry to your heart's delight, but tell what you underwent. At the end of that she says, and he gets convicted. Suppose she was only crying, easy case for acquittal, and the lawyer will ask all kinds of inconvenient questions. So this is where empowering the client, Sir said, empowering jurisprudence, empowering the justice process is possible with those kinds of insights. So bring them to your classroom, or make the students, facilitate them to experience. So in India, sir has already told, crime as a qualification is the sad reality that we are seeing. I mean, the more crime you commit, you become more qualified to contest election multiple times and to win also. And the systemic bias, for example, the way the sex workers are treated in the court. I had the project with Jaimala. I was writing the report. And we saw how the moment a sex worker is brought to the court, everybody, the whole scene changes, and the judge will make her wait till the day ends in the court. Oh, let them wait, kind of attitude. So Judicial Academy took it up in Bangalore under the leadership of Justice Kumar. You should bring Justice Kumar and make him discuss in the class these dimensions. And then the police, our study showed that one of the pimps used to be police, or sentries and all these kinds of people. So this kind of crime police network also something that could be, students could be made aware of, so that they don't get frustrated when they realize it afterwards. So preparing them for uncertainty, preparing them for the cruelty of the criminal law world is something. I have also given a checklist for legislative analysis and criminal justice administration. Some dimensions are there. Some of them sir has touched upon. I do not want to prolong. Already I have prolonged. So read these materials and enrich your class, and enjoy teaching criminal law in a total fashion, in a very profound fashion. So also learn enjoying criminal law, which is not just about crimes. Many people hesitate to become criminal lawyers, and girls hesitate to take up criminal law as a profession. Understand that no field of law is independent of each other. This is one of the fundamental dimensions. It's public law dimension. And if you are averse to criminal law, you are averse to the core of law, namely security and governance. So intermingling criminal law with corporate law, with the administrative law, intermingling it with economic dimensions is going to be the way, order of the day. Because unless it is economics, nobody takes things seriously. So cost-benefit analysis is something that you have to do while advising your client also. Thank you very much. If there are questions, we are open.